Call this work session to order. We're going to be discussing the MLP sale, and Mr. Weddleton just reminded me, if you have to speak and you're in the audience, please sort of come forward and or project, because the recorder is up here. We'll start with the roll call. Mr. Cross might have stepped out. Ms. Quinn Davidson? Thank you.
Weddleton.
Forrest Dunbar.
Christopher Constant. Felix Rivera.
Dick Trainey.
Pete Peterson.
Dyson.
Suzanne LaFrance.
Becky McPherson, Municipal Attorney.
Eric Croft.
Thank you. And the reason we do this roll call is so that people that might be listening to the recording know a sense of who's in the at the table, and also potentially who is speaking when they hear your voice. Okay, so I believe Ms. Wynn Pearson, are you going to be doing this presentation?
I am. I've been very lonely up here. I actually have a number of partners in time in the audience who are also here to answer questions and provide information. Mr. Slipko is going to talk with you today as well. And the entire CEA leadership team here to answer any questions. Also Mark Johnston, also our regulatory counsel, Dean Cater. So most of the audience is actually also sort of co-presenting. Before I start, I do want to pass out one additional exhibit, which we've finished on the interim between when I provided the initial deal documents on Monday and today. So I can pass these around, and there's additional copies for the public as well. So in terms of what I plan to do here today, as you all know, we have 3 essentially work session windows scheduled to talk through the details of this transaction. The first is today, and we are going to go through the asset purchase and sale agreement, which is the primary document, but which we will enter into for this sale. We're also going to talk about the summary of economic effects. Mr. Slipko is going to talk about the question of kind of where does the money go, and then essentially the Assembly gets to kind of make the decision about where the money goes and when does that happen. But what are the different income streams? Where are they proposed to go? What kind of latitude do you have to make decisions about that, and kind of when do you make those decisions? On November 15th, at the Enterprise Utility Oversight Committee meeting, we will talk about the PILT agreement. So that agreement governs who pays the PILTs, how is the PILT calculated, et cetera. So we'll talk about that. We'll plan to talk about that on the 15th. We'll also talk about the power purchase agreement, which is the document that governs what happens with the power from the Klutna hydro plant. And we'll talk about all those details then. On the 15th, Mr. Thompson will also be with us again to talk about any questions that you might have about the regulatory process. I think, as we've talked about before, the biggest delay that will happen after we sign the deal documents in this transaction will be reviewed by the Regulatory Commission of Alaska. And so you can ask any questions you might have about that process, what's going to happen there, what the municipality's role will be, what you guys' role will be, et cetera, what might the outcomes of that review be. And then on November 30th, we have Concentric Energy Advisors, our outside financial advisors, coming to talk about the financial aspects of the transaction and kind of predictions for what happens after this sale happens for all of us in the municipality as present or future Chugach Electric customers. I go through this in part to just to give a path forward, and also so you know when there will be opportunities to talk about different things, and we'll try and make sure we have the right constellation of people in the room to answer questions about each of these subjects on the days when they come up. But you're certainly welcome to ask questions about anything at any time as we go through. In terms of the materials that are subject to review, on Monday I sent you all the transaction documents, the 4 core transaction documents, which are the asset purchase and sale agreement, the payment in lieu of taxes agreement or PILTs agreement, the power purchase agreement, and the BRU fuel agreement. We've talked a lot recently, I feel like, about kind of assembly role versus administration role in document creation and document review. This is a somewhat extraordinary transaction. As we've talked about, assembly doesn't usually get every single document that goes into a transaction. In this instance, this is an extraordinarily important transaction for municipality, for all the residents of the municipality, and so we have provided those documents to you in advance for your review in the hopes that it'll enable you to have a full understanding of what each element of the transaction means for the municipality before you decide whether or not to vote to approve this transaction. And And a note on that also is that like any transaction that's subject to your review, the major terms are fixed. These are the current drafts that we're working under. There may be some minor changes as we move forward. The AO is phrased to accommodate for that, but you should expect that it's possible that as we get to the very end of signing these documents, as we get toward closing, there are going to be minor points that move in this. That's the case in any major merger and acquisition. It's impossible to freeze documents in time at one point and say nothing is ever going to change in this transaction on a minor point. So again, we give you the documents as agreed upon by the parties presently, as reviewed and agreed to by the Chugach board. But this is like any major complex merger and acquisition, something that those administering it will need to be able to make some minor tweaks to as we finalize. In terms of who's seen the, yeah.
Can you let them know that this is the way the documents are in their binders?
Yeah, so this is the order that they are in your binders, which I see you have in front of you.
Yes.
And I think they're all, or we do have copies for members of the public, I think. Are they over there, or are they?
Yes, for the members of the public, it's just a big stack of papers together. And then the CE is at the end, under the, just behind a blue piece of paper that Alex will be talking about.
Perfect, thank you. In terms of where these documents have gone so far, they've come to you. They've been previously reviewed by the Chugach board. We sent copies to the MLP Advisory Commission. We've also sent copies directly to the Regulatory Commission of Alaska. They're also publicly available here and in several other locations. They're on Power Anchorage. They are on the second website. The lengthy one is the question and answer page about the sale. It's on the Muni page. The third is the Assembly front page. They're the top item right now there as well. So there are multiple different locations. People can access them publicly, and they are public documents. You're welcome to share them with all of your constituents and solicit feedback. So today what I'm going to do is basically, I apologize in advance, this may not be wildly exciting. We're basically going to page through the asset purchase agreement and talk about what it does, what the terms are, and then what we've agreed to, what Chugach has agreed to, what we're keeping, what they're going to take, etc. We're going to go through all those nuances, and then I'm going to turn it over to Alex to talk about the economic effect, and again, kind of the question of where the money goes. You're welcome to either pull questions to the end or interrupt me as I go. Either one is fine with me. And again, the asset purchase agreement is the first agreement in your binder if you want to follow along in your hymnals. So first question, asset purchase and sale agreement, what does it do? Basically, I mean, this is the agreement, like anything when you're selling an asset, it goes through, what are we selling? So we're selling most of the assets of the utility. What are we not selling? An example, one of the things we keep talking about with Chugach is how we're going to treat the mural on Plant 2A, which the municipality will retain some rights to make sure that that isn't painted over or taken down, and so that we make sure that we maintain that important public art project. It also talks about timing. When are we going to close? When are we going to actually do this deal and transfer all of our assets to Chugach? And then how much are we going to get paid? So it's basically, if you've ever bought or sold a house, it's a more complicated version of what you signed when you bought your house. So if you look through the agreement, Article 1 is definitions. So as if you're paging through anything you see capitalized, you have a question about what it means, go back to Article 1. Those first 17 pages are all definitions of terms that are used throughout the agreement. Getting to Article 2, this is what are we selling? What are we selling? What are they buying? What are we keeping? First thing, what are we selling? So 2.01 goes through everything that we're selling. We're selling our real property. That includes our substations. It includes everything we lease. It includes everything we own. It includes, again, anything that's affixed to the realty, anything that's attached to the land, basically. We're selling all our personal property. We're selling all the machinery in the plants. We're selling, I'll apologize to Mark and others who work in the industry if I'm oversimplifying the nature of the property that we have, and we can ask him any specific questions. We're selling all of that. We're selling everything that we have at the Beluga River unit, which is addressed separately in here. It's essentially the same things, our real property rights, our personal property rights, our contractual rights in that interest. We're transferring our contracts. So any contracts we have that benefit the utility that are necessary for the operation of the utility will be assigned to Chugach. They'll have the benefits of those. We're selling our permits. So many permits that we have that enable us to operate the utility will be transferred. We're selling our right to pursue certain claims and lawsuits. So if there are claims that arise, they're going to get some of those rights as well. We're transferring any of our prepayments. If we prepaid something, they have the right to anything, any entitlement that come out of that. We're selling certain insurance benefits arising out of the assets that we're selling. We're selling our books and records related to the utility. And we're selling our goodwill, which I think is interesting. I think that's a term that's more standard. These are we're really operating from very standard merger and acquisition documents that really follow the terms that would be in place in any commercial M&A deal. Personally, I think goodwill is more relevant in a situation where you're dealing in a competitive industry and it's a brand name that's going, but we are selling ours such that we have it. Mr. Dyson, yes.
Mr. Dyson.
Yeah, thank you. Harkening back to our earliest discussions on this, there was a concern by MEA that almost a gentleman's agreement to work together on some distribution nodes or switches, and they were concerned that the new entity might not continue those things that are in progress. So I said that very clumsily, but there's a section here about agreements and obligations and stuff. So how could we assure MEA that their interests are being taken care of, or are they paying attention?
I might defer that question to Mr. Johnson and Mr. Siebert to talk about. I'm not sure I am aware of exactly the MEA nodes and switches. Is that the transmission?
Yeah, I'm not sure. I think it had to do with wheeling power, but
Yeah, we've been working with Matanuska Electric Association on an MOU, and it looks at the Eklutna transmission assets,
Yeah.
basically the transmission lines that come from the power plant, the hydroelectric plant into Eagle River and then down into Anchorage. So we've been working with them since we acquired the assets from MLP. We are in turn working on an agreement with MEA to sell some of those directly where they have 100% ownership. Some will be 100% owned by Chugach and some will be a 50-50 arrangement. But all that is being worked out in a memorandum of understanding between Matanuska and Chugach.
And I accept that at face value. My memory, it wasn't that it had to do with the Eklutna water plant. It had to do with power being wheeled north.
Oh, okay.
And there was something that was going on that made that more efficient or more fair or something.
Okay, so the other thing that we've been working with Matanuska Electric on is the Teelan substation. And there, it's a little bit of an unusual situation. Chugach owns the Teelan substation, and MEA power goes into that substation and back out to some of its customers. And we currently charge them wheeling because they're using the substation. The discussion we're under is selling some of those assets at Eklutna to MEA, so they would be able to sell directly to their customers without wheeling.
Okay, everything you said after you were working with them with MOA and good with faith answered my concern.
Okay.
Could you state your name for the record, please?
I'm sorry, my name's Lee Thiebert. I'm the CEO of Chugach Electric.
Wonderful. Please continue, Ms. Swin-Pierce.
Thank you.
Certainly. Next part of Article 2, what are we keeping? There's some things that we are going to keep when we sell the utility. There's a provision for excluded real and personal property, which refers to an exhibit, which is not yet finalized, but the parties will be negotiating which assets the municipality will potentially keep or keep some rights to. So the mural is one of them. We're not going to actually keep title to the mural. We're probably going to keep some kind of easement that lets us cross over that property and some kind of license to be able to clean it and fix it. There's a fire station property on Government Hill that we are contemplating keeping rights to because my understanding is that it is full of storage and not necessarily useful for the newly unified utility. And so we've been talking through those nuances. So there will be certain elements of real and personal property that we do not sell that are not useful for the new utility. And that has been part of the deal from the beginning.
Mr. Tranny has a question.
Becky, will we be able to have a breakdown on the cost of the mural as far as maintaining it, changing it? And
I can ask for that. I haven't yet worked out that level of nuance with the curator of public art, but I can certainly ask her what we think. And we've been talking about kind of how would we pay for that and what would we do with that.
and I'd like to know what type of labor is involved on a regular basis to change that.
Okay, sure.
Thank you, ma'am. Chairman.
Benefit plans, clearly our employees will no longer be our employees, so we will keep our benefit plans, keep our unrestricted cash. We will keep shared facilities and assets. I think my best example of this is the SAP program, which is shared by MLP with the rest of the municipality. We will keep that. We will not be selling any part of it.
Is it they didn't want
We
it or
tried
what?
our hardest
We'd like to sell it all.
Accounts
Gave us money
receivable.
not to take it.
Accounts receivable we'll keep from prior to closing, and the biggest thing, we'll keep our Cluna assets. Talk about what responsibilities are being taken over by Chugach. So in addition to feeding to the benefits of certain things, they will also take on liabilities for things like contract liabilities that arise after closing. Yes.
Just because it came up again on Eklutna, remind me, we are keeping the asset, right? Are we also keeping the water rights?
We are keeping the, I mean, you mean that we're not, are
Well,
we
I believe
keeping the water rights?
MLP has the right to, like, either a significant portion or almost all of the water that flows down that pipe, and then we give some of it to AWU, and we use some of it for generation, and that comes from a federal agreement. Is that right to the water being transferred to Chugach, or is that being held as we hold the actual generation plant?
What I understand is we are holding all of the legal rights to the property, including the right to the water, but that the right to all the power that comes from that water will belong to Chugach.
Okay. Thank you.
So they are taking over our BRU obligations, our Cluna obligations, our environmental obligations that arise after closing, with a carve out, which I'll explain later for sort of environmental issues that come up within a certain period after closing. We have an indemnity provision that covers that. Claims in progress related to the purchased assets. Taking over employee leave, which is an important piece. We're going to try and transfer all our employees with their leave in place. And that will be, I'll talk about that in a moment, about how we deal with that in the purchase price, so we aren't leaving all of our employees with no leave when they move over to an employer. And then other liabilities arising from the purchased assets after closing. This is more of Article 2. More of Article 2, what responsibilities are we keeping? Keeping our accounts payable obligations, keeping our transaction costs, everything we spend on making this transaction happen, keeping our pre-closing taxes or MUSA obligations, that stays in our hands, keeping the environmental obligations that arise prior to closing.
Mr. Loudon?
Maybe you've said this, but so all these have a certain value. So is the agreement, I guess we have it here, I guess we'll see it, but on that date, we tally all that up and that's the purchase price?
No, so and that I'll get to next is kind of what are we being paid and how that adjusts. A lot of these, basically, most of these things are built into our sort of fixed, and we accept some risk in them. So if there's some kind of pre-closing liability that arises, we're on the hook for that. That doesn't change the purchase price under this rubric. And certain post-closing liabilities that arise, they're on the hook for that. Doesn't change the purchase price. There are two things that will change the purchase price. One is the amount of the employee leave accrual, and the other is what are excluded assets they don't take. And so those two things are the two things that where the value could swing. I'll talk more about it in a minute, but those are the two things that will actually impact how much money changes hands. The rest of this is kind of about allocation of risk. Both parties are taking some risk that the asset is either not going to be worth more or less than what we've agreed to sell it for, as you would in any transaction. Was there another question?
No, please continue.
Okay. There are a few specific pre-closing claims that we're keeping the obligation to continue to prosecute. We're keeping employee claims. I've had this question a couple times. If somebody has a claim against the municipality for an employment action that happened while they were an MLP employee, that stays with us. Their claim is still against us. It's not against Chugach. Any IGC obligations, clearly the debt of the utility, which is a key piece of where the purchase price is going to be directed. And then also any claims arising from pre-closing actions. this is to Mr. Weddleton's question, what is Chugach paying municipality of Anchorage under this deal? That is section 2.05. And it breaks down to the upfront payment, which is the 767, actually I'm off by a couple of zeros. I apologize. Oh, this is a perpetual problem. $767,800,000. So disregard my lack of zeros in this number. We're getting a much more larger payment than this. And then minus two things, minus the accrued leave liability and minus the net book value of the excluded assets, and that's the money that's changing hands at closing. We've talked about how there are two other components of this deal. There's an ongoing tilt payment that replaces the existing MUSA. It's also the power purchase agreement, but this asset purchase and sale agreement just covers the assets that are actually changing hands, and this is the amount of money that is being paid for them. And again, there's two offsets that we discussed briefly, which is how much leave liability we're asking Chugach to take on. That will be offset against the purchase price, and the net book value of that fire station on Government Hill and anything else that ends up being excluded from the property taken. Yes.
So just roughly, this accrued leave liability will be millions or tens of thousands?
My understanding is we don't have a final number yet, but probably in a couple million. It also depends vastly on whether or not employees elect to cash out some of their leave before they go or not. Once we sign this agreement, we're going to have probably potentially up to a year before we actually close, depending on how long the regulatory commission review process takes. And we do allow our employees to cash out leave up to twice a year, everything except for 80 hours. So if we have employees that say, the municipality's leave cash out policy is somehow better for me than cashing out that same amount of leave over at Chugach's, so I'm going to cash it all out. We might have very little left at closing, or we might, the alternative might be true as well.
But there isn't, if they don't cash out their leave, at least a portion of leave will go with them to Chugach, right? Okay, so it's not a huge incentive for them to do that unless they see something they particularly like.
Unless they are an employee. I mean, we give a fairly generous leave package to employees. I know a lot of employees in my department periodically cash out leave because they don't actually use the amount that they're given. And so we may have employees who think, again, our leave cash out policy here is better than it might be at Chugach. That's the only thing I can think of. Other than that, I think that people will want to take their leave so that they come to a new job with some leave in place.
Thank you.
Can the price change? Again, two factors are vacation, how much vacation do people have when they go, and what do we keep as an excluded asset. At this point, the plan is that Chugach will take headquarters, but we had talked about this as something that might have been one of those significant assets that might be something that we kept. So when will we close? So the timeline, this is Article 3, and we keep paging forward. As I just noted, closing may take up to a year after signing for us to get to closing. Again, it depends pretty much entirely on how long the regulatory commission process takes. Right now, your vote on this deal is scheduled for the 4th of December. After that, we'll sign the transaction documents. After that, we will file with the RCA. That will not be immediate, but that will happen as quickly as possible, hopefully in the beginning phases of the new year. The RCA has 180 days to review, but that can be extended by them. So that they may elect to take longer than that to issue their final approval. And then we've agreed in the document that we'll close within 120 days of RCA approval.
Mr. Traney had a question.
Becky, who pays the cost of the RCA?
The RCA cost is paid by Chugach because it will be a Chugach filing. We will also have representation there, so we will pay for the cost of having representation as part of that as well.
But the process itself, then, we'll have an attorney there to represent our interests, but the cost of the RCA doing this will be borne by Chugach Electric.
Well, you mean the RCA? There's no cost. You mean the cost of?
I don't know how often they have an issue like this come in front of them. I'm just wondering what the scale was on what they would charge for this.
Well, there isn't a charge. We actually refer to our regulatory counsel. I don't believe there's a charge that they will actually presently pay.
Please identify yourself for the record.
My name is Dean Thompson with the law firm of Temple, Huffman & Ellis. I served as regulatory counsel to MLP and the MOA in this transaction. And the salaries and ordinary costs that the RCA incurs is funded through regulatory cost charges that are assessed to all regulated utility bills, RCCs. And on occasion, they can, after a case is done, allocate costs to the parties, but it's very rare. Since both MLP and Chugach are regulated, their customers pay regulatory cost charges, and so there is usually no fee.
One other question I could.
Yeah.
180 days, that can be expanded based on what the RCA's desire to work on longer, or?
It can be extended with the consent of all of the parties indefinitely. Without the consent of the parties, the RCA can extend it one time by up to 90 days for good cause, but they have to report what that good cause was to the legislature.
Thank you, sir.
Mr. Dyson, you had a question?
Yeah, thank you. Wait a minute, I have a question for you. Would you explain to us just in general what the RCA's responsibilities are in looking at this kind of an agreement, or their purview? And then secondly, which of those items are liable to surface in their consideration of this agreement?
Yes. Very generally, what the basic approval that the RCA is going to be giving is for MLP and Chugach to amend their certificated service areas. Chugach's will be increased and MLP's will be significantly decreased. In order to do that, they have to find that the surviving entity, Chugach, is fit, willing, and able to provide service, and that this transaction is in the public interest. And that usually means looking at rate impacts going forward, and then any other benefits associated with the transaction. And so they will be looking at all of the agreements that Rebecca discussed, but I think their main focus is going to be on what the impacts are going to be on the MLP legacy customers and Chugach's customers.
And all the people that meter throughout the net, right? Through the interties and everything else, the cost of electricity to the customer, what the impact is there, correct?
Yes, to the extent that it would have impacts on other interconnected utilities, the commission would consider that.
All right. Thank you.
So,
Thank you, Mr. Chair.
also, quick question on RCA before we go forward. Can either you, Ms. Wynn-Pearson, or Mr. Thompson, was it?
Yes.
Can you provide an example of a sale or attempted sale in the state of Alaska that's gone through this process before? And then two, could you recklessly speculate on the strength of our case?
I'm going to defer to Mr. Thompson. All reckless speculation.
Yes, the most recent transaction was the GCI acquisition last year. Before that, there's one right now that's pending, Hydro One acquiring Avista Utilities rights, which includes Alaska Electric Light and Power Company down in Juneau. And yeah, those both were approved by the RCA in under 180 days.
And I assume they don't do, what do you call them, like pre-advisory opinions or anything like that, but do you have a sense on how likely we are to be successful at the RCA?
They do not give advisory opinions, and I think there's a good chance of approval because the commission rarely denies these types of requests. I can think of one 20 years ago that they denied because they thought that the purchase price was too high. And it didn't involve a municipal utility, it was a privately owned electric utility. And but usually these are approved, and they're approved within 180 days.
Wonderful. Thank you. All right. Please continue, Ms. Wynn-Pearson.
Certainly.
Yeah, may I
Yeah.
make a comment? You could sit down.
Okay.
I think when Mr. Peterson and I were in the legislature, we all had a apparent crisis on gas supply here in Upper Cook Inlet. And my pejorative but informed position is that was almost entirely an RCA precipitated artificial crisis. they were so focused on that time in protecting the ratepayers that they refused to let the investment go forward to build the infrastructure and the prices to float to the natural gas, stranded natural gas's actual value. So that kept anybody from drilling for gas. And it was an unbalanced focus on just looking after the ratepayer in the short term. That all has been cured. In the last 10 years, there's been a far more enlightened, in my view, and broader view from the RCA. But there's always those dangers, even with an independent regulatory commission that we only have in industries where there's an apparent practical monopoly. So anyways, something for all of us to watch out for at some times, but I don't think a current problem. And thank you for indulging me.
Thank you, Mr. Dyson. Ms. Wynn Pearson?
Certainly. So continuing with Article 3, with our trip through Article 3, what has to happen before we close? As we've just been discussing, we need to have RCA approval before we can close. We also need to finalize our ancillary deal documents. You see that listed in Article 3. We need to make sure that we have all of our, all the documents in place to assign all of our real property. We'll need some consents from some of our lessors. We'll need to do all the documentation required to assign all of our contracts. There's also a transition services agreement, which is a very common feature of mergers and acquisitions, where practically speaking, when you sell a business, you can't immediately cut every single thing over at the same moment. So sometimes there are things that lag. Sometimes there are, pieces of different types of systems that remain in place in one business for 2 months or something while they're transitioned to the other business. And so that's what the transition services agreement will cover, and it will need to be negotiated as we get closer to closing, and we know what those things are that we're going to have to spend some time transitioning. And then we're going to have to do documentation of any other specific requests. Like, again, our perennial favorite example, the mural. We'll have to figure out we have to put the documents in place in order to make sure that we can go on there and do whatever we're going to do with the mural.
Mr. Constant?
Thank you. Is this the place in which we'll see the embedding of the Title 21 undergrounding?
Embedding of the Title 21 undergrounding.
Right, we have the 5-year plan that we are operating under, and I think we've had discussions that was part of the negotiation.
Yeah, we have discussed the fact that the municipality each utility has a 5-year undergrounding plan. My understanding, and I'll let Chugash talk to this point, is that they will assume the municipality's Title 21 undergrounding plan and continue to deal with it as each utility will. So there's, post-closing that can be changed, and there can be things that happen in the 5-year plan, but my understanding is the intent is to honor those things that are not that. I'll let Mr. Hebert speak to that. Yeah.
Yes, Chugach has a 5-year plan for the undergrounding Title 21. The municipality, MLP has one. We'll just rotate that into ours, but we're making the commitment that we'll continue to have the same program that's put place by MLP.
And so does that show up in the terms of the document, or is this just kind of a standard policy?
It's pretty much a standard policy. I don't believe we have anything specific.
Yeah.
I've made the public agreement that I will do that, and we can certainly put it in writing if that's
I think we
required.
could probably throw it into the schedule of contract obligations.
Yeah.
You're assuming if we want to. It's not quite a contract, and so when I looked at the document, I wasn't certain that it's in there. But
So I think we're required by ordinance to do that, and then it's a matter of what gets done. And so I think we're obligated to make the expenditures per the ordinance. So I think you're covered there.
Mr. Peterson, you had a question?
Thank you, Mr. Chairman. So typically trying to underground 2% a year, is that correct?
That's correct.
And so that'll be the goal after the merger or after the purchase?
Absolutely.
Okay, great, thank you.
Okay. Let's try to move forward.
carry on. So Articles 4 and Articles 4 and 5 cover the warranties offered by the various parties. Rather than go through these one at a time, I have a graphic here that shows municipality is offering substantially more warranties than Chugach is. Is this normal? Yes, this is completely normal in a merger acquisition because we are selling the property. So we're making a series of, go through Article 4 that has the details on all these warranties that are offered by the municipality, that we are organized and authorized to do the transaction, that there are no consents required for the transaction that we don't have, that we have valid title, that we haven't failed to disclose some significant liability that we have that we're trying to transfer, that our contracts are valid and not terminating. It's a very standard list of things that of representations and warranties that a seller of a business would make. I don't know if you want me to go through them one at a time or if there are specific questions about any of them. I should say as a caveat also, this is an enormously complex amount of documents. I know that we're throwing them at you. I'm happy to talk about them at any time. Other members of the administration who've been involved in negotiating the deal are happy to answer questions at any time. We do have 3 work sessions, which is a decent amount of time. We also are happy to answer questions offline at any time to make sure that you have all the information that you need to make a decision.
Ms. On that, Ms. Van Pearson, will this presentation be available to the public?
I can ask to have it put up in all the same locations.
That'd be great.
Please correct the amount.
What's that?
The
Oh, yeah.
$748,000 selling price.
It's in thousands.
I apologize. It's been a busy week.
Don't send that to the public.
Article 6. This is another question that we as an administration have gotten frequently from various folks, including some members of this body. Will the operation of MLP have to change before closing? Can we still continue to approve contracts? Can we still continue to approve expenditures? What if we need to buy new widgets to replace our existing widgets in the next year while we're continuing to move toward closing? And Article 6 is what covers that. It includes this sort of fairly standard phrase that MLP can continue to make decisions in the ordinary course of business consistent with past practice and prudent utility practices, which is a defined term. But it also includes a list of things that would require consent of CUGAT before the utility can do them. That's the list that starts on page 54. And again, this is a pretty standard M&A term. And basically, the overarching spirit of the term is that MLP can't do anything that will really substantially change the value or operation of the utility without CUGAT's consent. And this breaks down what that means. So how high does the dollar value of a contract have to be before CUGAT is involved? What kind of debt could be incurred? What kind of raises can you give to your employees, et cetera? And we worked out the dollar value for each of these to attempt to allow the utility to continue to operate as usual, but honor the need to involve CUGAT in anything that really would substantially change the value of what they're going to be purchasing at the end of this story.
Forrest, quick question.
Yeah, Mr. Trainee.
Becky, on page 65, 6.09, public announcements, neither party may issue any formal written agreement, press release to engage in any organized press release and both agree on it. Is that standard language for a merger of this kind?
That is fairly standard language, and what isn't standard about that is that we've carved off some exceptions to that, acknowledging that the mayor or that any of you may be asked at any time, by the press or by your constituents, what do you think about this deal, or how's it going, or something like that.
So we're not bound by that.
And you are able to continue to answer those questions. What this is really designed to make sure is that when we issue our formal press releases, when we have a formal press conference, that the parties collaborate on those things before we do that kind of public communication.
Thank you, ma'am.
Yeah.
Thank you, Mr. Chairman.
Thank you. Please continue, Ms.
Question on that is that runs right until the closing of the transaction. Then that's
Yeah.
pretty much now going forward.
Yeah.
Thank you.
And then also the other caveat we have in there is if there's breach of the agreement, then that obligation doesn't bind either party. But as long as we're continuing to work collectively toward this is a very standard agreement that will collaborate on what we say to the public about the deal.
Great.
What could prevent us from closing? Article 7. Page 4 myself. So no RCA approval, clearly. We can't proceed if we don't have RCA approval. For lacking a material consent to move forward, or if there's some sort of failure of reps or warranties that causes a material adverse effect, there's a major condemnation, there's a major casualty. So basically, if there's some, this article sets out the threshold for all of those. If there's an enormous change in what's available to be sold, then potentially we don't move to closing. Article 8 is our indemnity provision. What liabilities does the municipality keep after we close? the transaction. We have a general liability if we indemnify Chugach for any breach of our reps or warranties, or any breach or non-fulfillment of covenant, this is called a tipping basket. It's also kind of a common structure in a merger acquisition deal. Effectively, we don't trigger any loss. We don't have any losses unless and until losses exceed $2 million, and then at $2 million, the basket tips over, and our liability goes back to the first million. So we start getting liabilities over every dollar that exceeded $1 million, all the way up to $30 million. And this is for, we said we had title to property. Turns out that there was actually some kind of issue, some kind of claim to the property. Chugach has to spend money to clear title to the property that they need, et cetera. There's expenses incurred there. Other representations or warranties that we made about what we were selling that turn out not to be true, and there's money that's expended by Chugach to address those situations. That's what this term deals with.
So I have a quick question, then we'll go to Mr. Croft. So let's say something happens and we owe them $10 million. What pot of money will that come out of?
That's a good question. I think that there's a couple different provisions built in here. First of all, that question would come to the assembly. You deal with the question of where we would appropriate that money from, and then the deal is structured such that if there is no money to be appropriated, or you elect not to appropriate money for it, then that money can be offset against amounts due under other parts of the deal. So it can be offset against money due under the other two income streams that are part of the transaction.
I see. So, but it doesn't sound like under any circumstance it would come out of, like our settlement account, for example, as if we had lost a major case and then we could go outside of the tax cap to recover it?
I think we could eventually get there if we said, nope, we refuse, we
They
deny
sue
any
us.
obligation here, sue us, and they sued us and we lost in court. Then we get to the structure where that's technically a judgment, which then is dealt with differently under the tax cap than a standard appropriation.
Thank you. Mr. Croft?
Thank you. So back on 7, what does happen if the RCA says no? I assume the likelihood, from what I know, I conclude the likelihood is not just a no way, but there's some thing they point out that might be curable. This says that conditions and obligations of the party don't come into effect until RCA approval is received. So it's not like it was an agreement and goes away. It never becomes an agreement until RCA approval.
It's the obligation to consummate the transaction. So we don't have to close if they don't approve the transaction. We're kind of both, we're effectively at a standstill. If the RCA says no, absolutely not, no way, no how, nothing you can fix, then we're back to the drawing board. Again, as Mr. Thompson noted, that's highly unlikely. A potentially more likely outcome is they might have some tweak they want to see in the transaction, or they may approve it completely as is. But if they say absolutely not, we are absolutely not permitting this to go forward, then under this document we're both done.
And we don't talk, or I didn't see it, but it's a big document. We don't talk about what we do then. It's just wide open. If we don't get RCA approval, are there provisions here about what we do, or we just go back to the
I think that the provisions here say that we keep our transaction fees, our transaction costs, so does Chugach, and that's effectively all we've done at that point. I mean, there's not a lot of other things to undo. Once we've gotten to that point, the document terminates. We're not consummating the transaction. They no longer are involved in decision-making about MLP. Effectively, the deal is just off if that happens. I don't know if there's other things you're looking to have, kind of how that, and I will say when we get to the PILT and the PPA agreements, those have contingency language in them that they clearly don't spring into effect until we close the deal.
Thank you.
Thank you, Mr. Croft. Please continue.
Certainly. We're getting closer to the end. There's also an environmental indemnification in Article 8 where we indemnify Chugach for environmental liabilities in excess of $25 million over 10 years. Our goal in negotiating that was to try and, basically the goal with this is things we know might be environmental problems, that they know might be environmental problems they're responsible for, some unknown catastrophic thing that happens in that 10-year period afterwards, we do have some responsibility for it that tracks back to us. So that's basically the spirit of this provision.
Mr. Dyson?
The potential there is contaminated soils. There's been long-term spills that haven't shown up.
Yep. Okay,
And transformer oils.
which is more or less contaminated soils too, right?
Yeah.
Can I ask another? I know I keep hammering this, but it's a topic close near and dear to my heart, which is responsibility of restoration of the Clutna watershed. Is that considered? And there is a federal agreement out there that I think 2022 or something like that. There's some deadlines. Is that considered an existing environmental liability, or how is that cost for that remediation built in?
Not covered by this agreement because that is not an asset that is being sold. That is covered by the power purchase agreement, and we have separate provisions of that agreement about basically passing on the liability for continuing to adhere to the Fish and Wildlife Agreement to Chugach during the period of the power purchase agreement.
Great, thank you.
Article 9, can the parties get out of this agreement? This is the termination provisions of the agreement. You want to page ahead there. Few limited instances where the agreement could be terminated by mutual consent. If the other party is in material breach, if there's a change in law that for some reason makes the agreement impossible to consummate, or if there's a failure to satisfy closing conditions by the end of January 2020, unless it's caused by the other party. So if one of us is just dragging our feet, the other would get the option to terminate. Material casualty or condemnation. There's a massive earthquake and all of the assets of MLP are flattened. That is what is also an option too. I mean, we would have other problems at that point.
Mr. Constant.
Thank you. So, assuming approval on December the 4th, and then 180 days is 6 months plus 120 days after that to come to agreement. That puts us at 300 days. That leaves 65 days till the end of the year. And then, so that leaves like a super tiny window if you look at that 1/31/20 date, should the RCA opt to take an extra 90 days because of the scale of this agreement. And so has there been a kind of any thought to making that date have some kind of a pressure relief so that in the case of an RCA proceeding that takes longer, that date can extend?
I can look back at the language of it. I mean, I think that I think there is a provision where if I believe read together all the other provisions that you would say, so that if the RCA somehow got our consent and took, I don't know, a year and a half to approve something, which again, I think sounds like it's way outside the realm of reasonable and normal, then that would be a reason why that would not come to that. I can look at it more closely.
Yeah, because, I mean, 180 plus 90...
But I think when
plus
when we
120.
reached that agreement on the 90-day as background,
Yeah.
we think that's more time than both parties think that's more time than we should reasonably need to get to closing once we have RCA approval. Because we have the time of the RCA approval to finalize all the details that we need to do. We really should have everything teed up, and we should be just dealing with the final details in that last 90-day period. So we believe that we should not actually need that full period, nor should they,
Right.
to get to closing.
Though, is that something then, by mutual consent, the parties could extend? The Chugach board agrees with the assembly to put an additional 90 days on the table.
Well, this is just an option. This is not a drop dead date the way that December is.
Failure to satisfy closing by 1/31/20 unless
Right.
caused by the other party.
It gives them the option to end, but it doesn't require it, right? It says, can the parties get out of this agreement, right? Or am I misreading that?
Yeah, you're saying, we're saying it gives the option to terminate.
So then we do have the right to extend that time frame should the material circumstances demand.
Yeah, we certainly do. I mean, it's just that we would then have the option to
Walk away.
terminate. A few big picture points to the things that were the major concern of this body, of the voters, of the public when we went into this deal. Protections for employees. So how do we know that our employees are going to be rehired and that they're going to have comparable positions and that they're not going to be laid off as a result of the transaction? And I would point you to section 605, which deals with covenants regarding employee treatment prior to closing and at closing. It talks about when offers will be given for comparable positions and what level of salary and benefits those offers will be given. And then I point you to our section 6.21, which has post-closing covenants regarding honoring those provisions of the ballot composition, and also post-closing reporting obligation for 10 years, which will involve Chugach reporting to the municipality on employees that were that were laid off in the course of the prior year, and certification that they were not laid off as a result of the transaction. To Mr. Dumbarton, if you want to talk about your question about the unionized employees, and I will say that the agreement is drafted such that, and if you give me a minute, I can pull up the exact provision, such that it states that, I think if you want to look at 5.06 on page 53, we understand that the transition agreement for our unionized employees is still under some negotiation and some approval process by the union, and so the way that we have drafted to this agreement is such that if the transition agreement is final and valid, then that governs. If it is not final as of the date of closing, then Chugach assumes all of the existing collective bargaining agreement and all of our obligations under that collective bargaining.
I'm sorry, which presumption is
I'm just
that?
looking at, so 5.06 addresses the transition
5.06.
agreement.
Oh, yeah.
Looking at where, I realize I think this is the only provision that addresses the assumption of the,
And this just became public, you said, a couple days ago?
Wednesday is when it went up on the website, so I don't know if you want to talk about your proposed amendment now, or if you want us to reach out to the
I'll just say from my colleagues, I had an amendment distributed that is not going to go forward, but it was sort of, because it's actually sort of directed at the wrong document. And I think this transition agreement probably covers what I'm asking them to do, which is when we put the question to the voters, there was specific language in there that said that Chugach was going to basically assume all the obligations of the prior IBEW contract, and the initial language that we saw didn't fully conform with that. But my belief from the administration is that is what 5.06 does.
And I think it's 5.06 read together. I think what I'd like you to let me do is I can send a follow-up message to you explaining exactly how the provisions of the agreement read together. We did a redraft of the agreement at one point as we were finalizing it, when we realized that the transition agreement was still subject to some discussion, to make clear throughout the agreement that if there isn't a final ratified agreement between IBEW and Chugach that governs how those employees transition as of the date of closing, that Chugach will assume the collective bargaining agreement obligations that we have just wholesale as they're required to by law, as they're required to by the ballot proposition. So
Okay.
I can outline that in greater depth and also talk about it a little bit more next time if that's helpful. And we can also reach out to members of the union to make sure that it's clear to them what that looks like. Because I agree with you
Sure.
that the term sheet just contemplated the transition agreement filling that gap as opposed to providing this kind of if this or this option that's in the actual final deal document.
Yeah, I would appreciate that email from you.
Certainly.
Let's continue.
Finally, protections for ratepayers. Section 6.21 also includes post-closing covenant not to have rates rise as a result of the transaction, and it includes this 10-year post-closing compliance reporting, so we will get a report every year from Chugach. Also, this is part of the RCA process, so rates of any regulated utility will be governed by a public RCA process as well, so we have that as sort of a double check on the rates of the utility, in addition to the terms of this agreement.
Mr. Constance, do you have a question?
Two things. One, way back at the beginning, liability is not assumed through the transaction. I'm assuming that the issue that we've experienced with our labor costs relative to SAP, these kind of correction fees that we have no idea how much they really are, these are kind of the items that are sticking with us,
That's
right?
staying with us. Any of those claims of any kind of, again, any other kind of employee claims from pre-closing, they stay with us.
And just as a matter of note to the public and to the Chugach folks, I know there was a specific term in your board's resolution that said you needed an audited financial statement, and we just had delivered to us by email a draft of the CAFR. So we're much closer than we have been.
Not audited though.
Right, but we're much closer than we have been. We're getting closer.
Thank you, Mr. Constance. So I intend to.
I was just going to mention.
Do I need a motion to do it, or can I just-
You can ask and see if it's unopposed. That would be great.
Yeah, I'm going to. Does anyone oppose a motion to or a move to extend this work session?
What time period, sir?
I don't know.
Half an hour?
How much time do you think, Ms.
At this
McPherson?
point, my review is done of the document. I would at this point defer to Mr. Slicka to talk briefly about the the C about where the money will go from the transaction, and then however long you might want to provide for additional questions or audience participation.
Mr. Slivka, how long is your portion?
5 minutes.
Let's go for 15 then.
I move to extend 15 minutes, Mr. Chairman.
All right.
That's
Thank
not
you.
a target, it's a.
It's a ceiling, not a target. Go ahead, Ms. Wynn
With
Pearson.
that, I will defer to Mr. Slivka to talk about where the money will go, or where it can go for the transaction.
So you should have in front of you a copy of the statement of economic expectations, economic effects.
Should be the last document in your binder.
There's not a slide for this.
Oh, it's just a-
So we'll start with the number that Becky talked about, $767,800,000. That's the expected cash payment that we're going to get. We expect that payment actually to occur in September of 2019. So absent, we don't believe that this will get delayed much beyond that. We're going to take that money. We're going to pay off all the outstanding debt. That's the $511 million. We're going to pay the termination costs for existing PERS Tier 1, 2, 3 employees. The detail on that assumption is in the back. Basically, if you're Tier 1, 2, or 3, we're guesstimating that's going to be $1 million because we have to make.
Sorry, Mr. Peterson?
Thank you, Mr. Chairman. So, a current MLP employee who's in the municipal retirement system, so this transfers that, I mean, they get to stay in the municipal retirement system?
What this
or-
assumes is you're working at MLP when the transaction closes and you don't go to another job. If you go to Chugach is not PERS. So in the condition we're going to shut down our PERS contract with MLP, for lack of a better word, I'm not sure that's the right term. If the termination study is done, they come back and say, because the fund is currently 80% funded, when you shut it down, you have to take it to 100% funded. The estimate is that it's $1 million if we owe you a pension. There's another 30 employees who are Tier 4, and we would just owe them the health care benefits, which we're assuming is $200,000. That money would go to the state.
All right, thank you.
Thank you, Mr. Peterson.
The other expenses indicated there are our transaction costs. Those are legal fees and advisory fees of $3.5 million. And then payoff of the SAP associated debt, which is $8 million. I would guess by the time this actually happens, it's going to be a little bit under that. You do all that math, you end up with $207 million is net. What we receive, and that money gets deposited into the trust fund and starts earning income.
So you said 207 million, but down here it says net income regulated to 78 million.
So there's some other items indicated up above, which, as Becky indicated, we retain the unrestricted cash and the accounts receivable and accounts payable. Those are currently net, $68 million.
And those are held by MLP right now, and they'd come over to the municipality.
We would retain them, yes. I've had many conversations with MLP's Director of Finance. We believe that number is right, but until we get closer.
Are there, sorry, before I go to you, Mr. Constant, are there particular restrictions on that money that doesn't apply to the other monies? So that 60-odd million?
It would go to the interpretation of it's the proceeds of the transaction. So, again, when we talk about what you have the choice of doing.
Is it the proceeds of the transaction? Because it's money we already hold.
Yeah, I think legally I would conclude it is not. I think it becomes that. There are many things in this structure too that go to what does the assembly want to do. So you can pay off the requirements of the ballot proposition of the charter. We have to first pay off debt using the proceeds of the transaction. Debt of MLP, then debt of the municipality, whether or not you want to pay off other debts of the municipality is an assembly decision, and then from there it goes to the trust fund. I would legally conclude this is not proceeds of the transaction, and you can decide amongst yourselves whether you'd like to treat it as though it is, or whether you'd like to treat it as something else, and something you mentioned.
Mr. Constant, you had a question?
Yeah, I would say it's the opposite. It's less restricted, but So the 3,500,000 there, we authorized, I think, $7 or $8 million. So we've been pretty frugal there.
Correct.
Thank you.
So, and again, so because of this item about this money, which is approximately, we estimate to be 68 million, it is not calculated in terms of the top line where we talk about the MOA trust fund incremental revenue. So those numbers are derived from a deposit of 207 million into the trust fund. And then the income earned, what this anticipates is the current 4.25% payout, and then that rises in 2022 to 5%.
So, Mr. Slivka, I've been very resistant, and I think my colleagues have been as well, to really discussions about what we do with this money until, we're still a long ways away from seeing it. But I am curious if you're starting any kind of preliminary analysis of, we could put this money into the trust fund, it spits out whatever it is, 5% a year, 4% a year. If logically, if we have debts that have a higher interest rate on them, or in some other way, a higher effective interest rate on them, are we identifying and targeting those debts? And obviously we should. Have you done any of that kind of preliminary analysis, or do you plan to in the near future?
I don't think we have done that because, and again, I would defer to Ms. Pearson, but I think the ballot proposition said proceeds go to the trust fund.
It says debts.
Yeah, I think we're just not that far along yet, honestly. This is a decision we have to make when we get to closing. So
Yeah.
we have been really focused on trying to get
Get
us
to
over
closing.
the hump of signing this enormously complicated deal. And so what we do with the money, I think that's the question, is we haven't yet analyzed that. If you would like to ask the administration to come back with some responses on what our debts are, what interest rates they're at, what we might retire, I think that's a question you should consider over the next 9 months to a year as we approach closing and decide what to do with the proceeds.
Oh, I think it'll become a very hot topic sooner than 9 months to a year from now. But I agree that we can wait till certainly after December.
You were suggesting when we talk about it now as we approach the closing 9 to 12 months, right?
Yeah, I would
Not
say
that we
this is-
should wait for 9 months.
Oh,
just to
yeah,
clarify.
certainly. Just as
Okay.
saying that we haven't been, our focus has not been on that as an administration because we've been working on negotiating the deal terms. But certainly that's
Sure.
the next piece, is figure out what you want over the next 9 months, how you might want to get the information you need and decide what you'd like to do with it.
Mr. Trainee, then Ona. Ms.
Since I've got a
Browse.
timeline coming up with this next election, I don't intend to wait that long.
Yeah.
I want the administration to give us a breakdown of the debt we owe by subject matter and percent of interest associated with that debt, so we can decide.
Yeah.
I don't intend to wait 9 months. I would like it by about February.
Yeah. We're still not buying that howitzer you asked for, though.
No,
I have
Ms.
one.
Browse.
What's your problem?
Mr. Chairman and Mr. Trainee, we have had conversations internally about making sure that those exact calculations are part of our process. What's the interest rate at the time of closing or after our CA approval or wherever the circumstances are? I think some of that analysis is a little premature right now, only because we won't be able to project out that far. So we have had that conversation and will be able to get you all that information.
Mr. Mayor.
Good, and it's very encouraging that you're already spending the money, which is an indication that you're going to support the deal. But let's not spend it until the deal's done.
Right. Close the deal.
Sure.
Nobody would like to know what's out there, Mayor.
Sounds like a
Get
capper.
the deal closed.
Go ahead, Mr. Slivka.
So we can certainly provide what our current outstanding debts are today, so you can understand.
appreciate
I don't
it, sir.
believe we're paying in excess of 5% on anything.
On anything. Yeah. Mr. Peterson?
Thank you, Mr. Chairman. Well, I would think if we had a lot of bonds that we were paying a high interest rate on, we would have refinanced those by now.
Yeah.
So I doubt if we've got a whole lot of
Well, some-
expensive bonds out there.
Sometimes things aren't that straightforward. Like we did with the certificate of participation
Right.
situation, we were effectively paying an interest rate on that, right? And we effectively refinanced something that wasn't obviously a debt in that way and brought down our yearly payments on it. Mr. Trainee?
Every administration's doing a great job refinancing our old debt. I just want to make sure there's not something hanging out there that we don't know about. I can take one look at it, just to let us know.
Mm-hmm. Mr. Slivka?
So just to, again, to finish up with the assumptions, assuming that the money goes into the trust fund, that top line would show you what the increased impact in terms of spending. So that would be an additional 8.8 million in 2019. beyond the $6+ million you're already getting. This doesn't address the MUSA PILT payments because we assume that those will continue in the same level they are right now. This also highlights the power purchase agreement payments, and that those payments will be received, and that there's potential earnings that could be generated off of those payments depending on where they are deposited.
Okay. All right. Any closing questions from Mr. Slifka or from Ms. McPherson?
Just a comment.
Go ahead, Mr. Klaas.
I just want to say thank you to all the parties around the table. I'm looking forward to diving deep into this, but this is the first breath of fresh air I've heard in the city that's very concrete and tangible that we can look forward to should we get this deal closed. So let's get this deal closed.
Okay. With that, this work session is closed.